Good morning. I'm Parole Officer Tricello, and I'm hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Shaie Campbell, inmate number 420120. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in your correctional institution. Can you please state your full name and DOC inmate number for the record?
Shaie Campbell, 420120.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica and Parole Officer Shaie. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Ms. Campbell this morning.
Thank you. And Officer Shaie, can you please identify yourself for the record?
Yep, this is Parole Officer Shaie, Women's Reentry Unit, New Haven, Connecticut.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Ms. Campbell and Officer Shaie, can you please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, ma'am.
Thank you. Officer Shaie, you agree?
Yep, I agree.
Thank you. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have the opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So you have a few rights to today's hearing. The first, you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes, ma'am.
So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
Perfect. So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. Before we start, I do want to note on the record that a no finding was made for charge number 1. And legal obligation, and charge number 4, mental health evaluation and treatment as deemed necessary. And I have not received any additional evidence related to those charges, so we're not going to take those into consideration today. So we do not need to review them for the hearing. So Officer Shaie, can you please read for charge number 2, condition of drugs, the information underlying the charge?
Sure. Charge number 2, drugs. On 12/19/2024, on or about this date, you used cocaine and rendered a positive urine for cocaine and THC. Based on this action, you're in violation of release direction. Obey all laws. Charge number 3, halfway house placement. On 12/20/2024, you exhibited aggressive sexualized harassment behavior towards another inmate resident at Rise Halfway House. This violated the space of the other offender, and she reported feeling unsafe and uncomfortable. This is a violation of Halfway House Agreement number 7. I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties.
Thank you. Also, the evidence submitted by the state was identified and marked at the preliminary hearing. And again, I have not received anything new or additional, so that all remains the same. So counsel, just to review, you and your client received a notice of parole violation, the parole violation report, and all the evidence.
Yeah, we had that. for the previous preliminary hearing, yes.
Perfect. I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes.
All right, do you need any more time to submit any additional evidence?
No.
Okay, so today we do not have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. So Officer Sheehan, would you like to make any statements towards the charges?
No, I think the violation speaks for itself.
Counsel, is now your opportunity.
Charge number 2, as written, no comment regarding the drugs part. P.O. Sheehan, I have a question for charge number 3, where my client is charged with aggressive sexualized harassment behavior on or about December 20th of 2024. I have a question regarding the evidence that was submitted, specifically Exhibit L. Do you have that in front of you, or do you have access to it on your computer?
I do.
Okay. Do you know, I have a copy.
It was the statement.
Yeah, it's marked, I think it's text messages. It's 3 pages. It's Exhibit L. And it has the name of an individual on the top left-hand corner with a phone number. And then it starts with, "Thank you, you mad at me?" ? And it has a Cash App download. And then the first sentence is, "To tell you the truth."
Yes, I do have that right in front of me. Yep.
I have a question, and mine is photocopied from when the evidence is submitted to the Board of Pardons and Parole. Do you know what date these text messages were exchanged?
I would have reviewed them within that day, so I don't actually have it in the text message, it seems.
Okay. So I'm on page 2, about halfway, 3/4 down. Do you see there's a couple of kind of smack in the middle of the page? It says Wednesday at 10:39 a.m. And then there's one Wednesday, it looks like 5:44 p.m.
I do see that. Yep.
Okay. So is it fair to say, I know, once again, I don't have a date. My client, I know, was out briefly. So she was paroled on December 10th and then was remanded on December, roughly the 19th. Is it fair to say these text messages were exchanged during that 9-day frame?
I would say so, yes.
Okay. All right. And I'm just going to put on the record, and I think I alluded to it at the preliminary hearing. What my client is charged with is this aggressive sexualized harassment. And clearly, I think we agreed that this exchange took place while my client was out in the community. And in reading and in not reading between the lines here, I don't think my client exhibited that type of behavior based on the interactions she had with the alleged victim in this case. And the only other comment I want to make regarding that charge number 3 on the halfway house claimant, I believe you already asked the parole officer. We have not received any new evidence regarding that charge. I know that it was alluded to at the preliminary hearing that the state police were involved in some type of I don't want to say investigation. They were contacted to follow up, and as of March 3rd, 2025, I have not received any additional evidence regarding my client or if anything been processed. But that's my brief comment regarding the 2 charges. I do want to be heard about her background at the appropriate time. Thank you.
Thank you. Officer Sheehan, any last comments before I move forward with my finding?
Nope. State police did not press charges.
Okay.
Thank you.
Thank you.
That's correct. Yep.
Counsel, sorry, any last comments?
Well, yeah, my only comment based on that the state police are not pressing any charges. We are at a different preponderance of the evidence standard for this hearing here. It's not probable cause anymore. So to further bolster what was previously said at the preliminary hearing. I know that one's probable cause is a bit lower standard, but now we're at a higher standard here. So there was an alleged allegation made. It appears to me, and I don't want to put words in the parole officer's mouth, investigation was done by the state police, and I believe her quote was, "They're not pressing any charges." Thank you.
So I am just going to take a few moments. I just want to review one. So I have reviewed all of the evidence as well, and I've listened to the testimony today, and I'm going to announce my findings. So for charge number 2, condition of drugs, I am going to make a finding of based on states exhibit A, D, H, and I. For charge number 3, condition of halfway house placement, I'm going to make a no finding based on the evidence submitted and the testimony today stating that the state police did not pursue any actions against Ms. Campbell. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And once the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to determine what outcome I will recommend. So Officer Sheehan, would you like to make comments towards Ms. Campbell's background and history?
No, I was able to review it and I have no additional comments.
Okay, great. Thank you. On counsel?
Yes, on behalf of Ms. Campbell, I am asking to have my client reinstated as soon as possible. I know it's a matter of days that she was out in the community based on what happened here. But between the preliminary hearing and now the revocation hearing, there were initially 4 charges that were brought against my client. There were 3 no findings. The only charge that's left is a dirty urine, positive urine test on December 19th of 2024. My client has been incarcerated since December 19th of 2024. If my paperwork here is correct, this is her first violation of special parole. She did previously successfully complete the timeout program. She's 35 years old. She does have 2 children. On the previous release, she was at the App Foundation, looks like May 23rd, 23 to May of 2023 for inpatient substance abuse treatment program in New Haven. Already indicated in September of 2023, she did complete the timeout program in York. She did graduate from Litchfield High School, did previously have was a certified nurse's aide. I believe that certificate has expired. She does want to renew that and does have a history of in the homework and the independent contractor doing healthcare. She was last employed in a nursing home, and she is, since she's been incarcerated, does attend various groups 3 times a week, including coping skills, recovery, Sister Standing Strong. And one of those programs is run by peers in the facility. She would like to return to the Connection halfway house in New Haven. It's a backup plan. She's amenable to being placed in a halfway house in the Hartford area. So I indicated she does want to renew her nurse's aide license and interested in enrolling in licensed practical nurse program. That's kind of been her history of work. And she had applied to it's like Philly's A Taste of Philadelphia in New Haven. She put in an application, was remanded, and it does want to follow up that to get working, and obviously is eager to build her relationship again with her 2 children. Thank you.
Thank you. I have listened to today's testimony and reviewed all the evidence that has been submitted. And based on that, I am going to recommend your parole be revoked, Ms. Campbell. You serve an approximate 2-month and 3-week period of confinement, and that's with the re-parole date of March 13, 2025. That is my board review date as well, council. So,
13, I'm sorry,
sorry, 3/13.
3/13/20.
2025, correct. So that, with that, I'm gonna also recommend the following conditions: no alcoholic beverage consumption, no contact with the victim PB, a general no contact with MB, and a mental health evaluation and halfway house placement. Ms. Campbell, I just want to point out though, if you need to work on some of your behavior, because 9 days after being let out and you're back, it's gonna be a long time of special parole for you, for us, for everybody, okay? So just
Yes,
try to get
ma'am.
some help out there. Ask your parole officer for help if you need help. Try to just make some changes, okay?
Yes,
So my
ma'am.
recommendation is going to go to the board on that date, March 13th, 2025. On that date, the board can adopt my recommendation, or if they want to do a sanction longer than what I've imposed, you'll have a supplemental hearing, but you'll be notified of it and you'll be present for that hearing because they'll want to address concerns with you themselves, okay? Do you have any questions today, Ms. Campbell?
No, ma'am.
Council, are good?
Yes, if I may just add, you are on special parole. She indicated, Shauna, it's going to the board on March 13th. It goes at 9 o'clock in the morning. If they adopt the recommendation, you get released that day. If you don't get released, that means they rejected the recommendation. I'll set up another call with you. I have to explain the supplemental hearing procedure to you as the hearing examiner just put on the record. So the way you're going to know if they adopt it, you're going to get released that day. If you don't get released, there's an issue, and I'll reach out to you.
Okay.
All right, good luck to you. Thank you for your sharing.
This concludes the
Thank
revocation
you.
for Shauna Campbell, inmate number 420120. All right, Ms. Campbell, you're all set.
Thank you.
Yeah.
Good luck.
Thank you.
Good morning, Mr. Neal.
Good morning.
Perfect. All right. So we can't start until exactly 9:30. It is 9:23 right now. So in about 7 minutes, we'll get started. And I think your attorney just got here. So unfortunately, we have to wait the 7 minutes, though, okay?
All right.
All right. We'll talk to you shortly. Good morning. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Quinton Neil, inmate number 3000198. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Cybulski Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Quinton Neil, 3000198.
So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Neal. Good morning, sir.
Good morning.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Counsel, is it okay if I swear your client in?
Yes.
All right, so the testimony at today's hearing will be taken under oath. So Mr. Neal, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today's hearing. You can put your hand down. You're all set. Thanks. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So we have, you do have a few rights to today's hearing, and we're going to go over them right now. So first, you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice, Mr. Neal?
No.
That was the paperwork that you got. It was probably a little while ago when you first came back to jail, but they brought you a package of paperwork. They either handed it to you or sent it to you that had all the information contained in it for this violation.
Oh,
Do you
I
remember that?
received that. Yeah, package.
Yeah, it was a while
A
ago.
while ago, yeah, when you first went back in, like
Yes.
Attorney Dean said. So you did receive that?
Yes.
Okay, perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're going to go over the charges now that the state your parole officer is bringing against you and the information underlying each charge. All right, so for charge number 1, condition of halfway house placement, the charging officer reported that on 1/26/24, you were placed at the Aileen O'Connor halfway house in Hartford. You signed a halfway house agreement acknowledging the written rules of the halfway house. On 4/16/2024, you were found by halfway house staff to be smoking cigarettes in the bathroom during out. This is a violation of the written rules of the halfway house. Specifically, I will not use tobacco products within the halfway house, and I may only smoke in designated areas at designated times. On 4/16/24, you were found by halfway house staff to have marijuana hidden on your person. This is a violation. I'm not going to read that part, those parts, okay? I'm going to skip this is a violation of the conditions. Is that okay?
That's okay.
All right. On 4/21/24, you refused to take your insulin that was prescribed to you. On 4/29/24, you urinated all over the floor in your bedroom at the halfway house. On 5/6/24, you were found by halfway house staff to be smoking cigarettes in your bedroom. On 5/7/24, it was reported by your treatment provider that you did not attend your appointment on 4/16/24 and 4/17/24, despite sending out of the halfway house on a pass for these appointments. Your whereabouts in the community were unknown during these times. On 5/9/24, you were found by halfway house staff to be smoking cigarettes in the bathroom at the halfway house. On 6/21/24, you were found by halfway house staff to be smoking marijuana on the grounds of the halfway house during a smoke break. On 8/22/24, you were found to be smoking cigarettes in the bathroom at the halfway house. On 8/25/24, on 2 separate occasions, you were found to be smoking cigarettes in the bathroom at the halfway house. On 9/6/24, you soiled yourself during a medical incident. You were instructed by halfway house staff to change and wash your clothes. You refused to follow the instructions of halfway house staff and remained in your soiled clothes. On 9/7/24, you were again instructed by halfway house staff to shower and change and wash your soiled clothes from the previous day's medical incident, and you refused to do so. You did not comply with staff's instructions to shower and change/wash your soiled clothes until 9/10/2024. On 9/7/24, cups full of urine, spoiled food, and empty soda cans were found by halfway house staff on the side of your bed. On 9/7/24, you were instructed by staff at the halfway house to clean your room. You responded by calling the staff a fucking faggot, a dirty cunt, said fuck you, I'm not a fucking kid. On 10/17/24, you were found to be smoking cigarettes in a bathroom at the halfway house. On 12/5/24, you were found to be smoking marijuana at the halfway house. You were instructed by staff to stop and instead continue to smoke and blew the marijuana smoke into the staff's face. On 12/19/24, you reported to staff at the halfway house that if you get into trouble, you are going to attack him, referencing another resident that you believe to have reported on you to staff. On 12/20/24, based on your ongoing pattern of disruptive behavior and that your actions pose a significant safety risk to the facility and its clients, the program director at Alien O'Connor requested your immediate removal and unsuccessful discharge from the halfway house. On charge number 2, condition of mental health treatment, on 9/3/24, it was reported by staff at Wheeler Clinic, your mental health treatment provider, that you were not compliant with a psychiatric evaluation as stipulated by your mental health treatment condition. For the exhibits that have been submitted were identified at the preliminary hearing and marked at the preliminary hearing, and they all remain the same. And I have not received any new or additional exhibits to identify at this point. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we did.
I also received the defense's exhibit 1 on list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes.
Do you need any time to submit any additional evidence?
We do not, no.
So we do not have any witnesses today, so that it is now the defense's opportunity to call any witnesses, present evidence, and speak to the charges or any of the evidence submitted.
Yes, thank you very much. As to the first charge of halfway house placement, I just want to note that as to the situation, the medical incident on 9/6, it was, I believe, a somewhat severe situation where my client had a seizure. And then thereafter, I believe on 9/7, they note that he hadn't changed his clothing. He was still feeling very badly after having that seizure and was trying to wash his clothes, but he reports that there were multiple instances where he went down there and the washer and dryer were either in use or someone was already basically in the queue to utilize them. So it wasn't a lack of him just refusing to change his clothes. He had no other change and was unable to use the washer due to other people utilizing it. I would also just note that for that first charge, Exhibit F doesn't appear to be signed by staff or the client. And there has been specific evidence submitted to show that my client received the program handbook that's referenced. So I would just argue that that shouldn't be considered. As to the second charge of mental health treatment, I would argue no findings should be made. Exhibit A of the parole conditions doesn't specifically indicate where my client needed to engage in treatment, the specific agency or location, and it doesn't indicate what the treatment's for. There also is not specific evidence that's been submitted indicating that my client received that information of the location and time and information for the program, and then with that still knowing they refused to participate. So I would argue there should be no finding on that. And then at the appropriate time, I would like to remark on his background, history, and future plans. Thank you.
Thank you. I'm gonna take a moment, I'll let you know my findings. Okay, so for charge number one, I do find, Mr. Neal, that you violated the condition of halfway house placement based on the state's exhibits A, D, E, F, G, H, I, J, K, and L. And on charge number two, I'm also finding that you violated the condition of mental health treatment based on state's exhibits A, D, and J. So that does conclude the fact-finding portion of today's hearing. You will now have the opportunity to speak to your background and history, and once you're concluded, the purpose of this part of the revocation hearing is to help determine the outcome. So would you like to make a statement?
Yes, my client, Mr. Neal, is 39 years old, born in Hartford. His primary source of support is his close friend, Miss Upshaw, who resides in the Hartford area as well. He has two children, ages 17 and 16 as well. Upon his release from Osborn to community release in January of 2024, my client was placed at Eileen O'Connor House, where he was up until his remand. He completed his sentence on April 5th and then began his special parole supervision. While at Eileen O'Connor, he reports that he was working with a job developer. He had 3 different positions. He was full-time at Aldi's for about 4 months. That was in South Windsor. Part-time at JCPenney's distribution center in South Windsor for about 2 weeks, and then was about to start working as a cook at Buffalo Wild Wings in Manchester. That was scheduled to start January 2nd of this year. Per the records that we got from Eileen O'Connor, it appears that he had been doing the Ascend and Stick to the Script groups at Script in Hartford, where he was doing, he reportedly continued attending after successfully completing the groups. He also was doing DBT, dialectical behavioral therapy at CRT in Hartford as well. Although part of the violation indicates the Wheeler Clinic situation, he does report participating in treatment there from June of 2024 up until December of 24. He specifically reports participating in outpatient services, individual therapy, and medication management. At the location in Hartford. He also had a clinician there, Ms. Katari, who he was doing medication management with. He also had an APRN as well at that facility. He has a number of different medical situations, including seizures and diabetes. He has a neurologist that he sees in Hartford. He also has a history of a traumatic brain injury. While in the community, he was on a maximum contact schedule, but his regularity of contact was good. Upon being remanded, he has been attending school to try and get his GED. He's been taking medication, and he has been employed in the kitchen working every day of the week. Upon reinstatement of special parole, he's open to a halfway house in the Hartford area. He wants to finish getting his GED and start a business management program. He's hoping he can go to that job that he had obtained at Buffalo Wild Wings in Manchester, and is open to any sort of treatment recommended, and is hoping to reestablish clinical services and medication management at Wheeler. He's also hoping to previously resume his medical situation that he had started treatment for while in the community. This is his first violation, I believe, on this bout of special parole supervision. He was remanded on 12/23. He's already sat in for approximately 2.5 months. I would ask for a sanction not to exceed 3 months for Mr. Neal. Thank you.
I have listened to the testimony today. I also reviewed all the evidence that has been submitted. Based on that, Mr. Neal, I am going to recommend your parole be revoked and that you serve an approximate 3-month period of confinement. That's with the re-parole date of March 23rd, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverage consumption, no contact with EN or PS, the victim's family, without your parole officer's permission, mental health treatment, and halfway house placement in Hartford. So that is my recommended sanction, and that's going to go to the board on March 13th, 2025. So on that date, March 13th, the board can either adopt my recommended sanction, they can lower it and ask for you to be released that day, or they can want to do a supplemental hearing if they feel like they want to keep you incarcerated longer than what I've recommended. If that happens, you'll be notified because there will be another hearing that you'll be present for to address their concerns.
So Mr. Neal, if you want to call my office next week on Thursday in the afternoon, we can let you know what the board decides, okay?
All right.
All right, but hopefully if they take the recommendation, you should hopefully be getting out 323. They just have to have the final say, okay?
All right, so call you Thursday.
Yep, not this Thursday, next Thursday, the 13th, okay?
All right.
All right, take care. You're all set.
What's your name?
I'm Attorney Dean. I'm your attorney for the case, Hannah Dean.
All right, Kennedy.
Hannah. Hannah with
Oh,
an H.
Hannah.
Yep.
All right.
Mhm.
All right.
Yep.
So if you don't get in touch with Ms. Dean, if you walk out the door on the 23rd of March, that means they accepted it.
Yep, exactly. Yep, if you get out the 23rd, then they accepted it. But if you want to know before then, call my office, okay?
All right.
All right, thank you.
You're all
Yeah,
set,
thank
Mr. Neal.
Yeah, thank you.
Take care.
Have a good day. This concludes the revocation hearing for Quinton Neil, inmate number 300198. All right, take care, Mr. Neal.
Yeah, you too. Yeah.
Good morning, Officer Goodman. How are you?
I'm good. Good morning. How are you?
Great, thank you. We are gonna try to start with Mr. Hotchkiss, so hopefully they're normally good in New Haven, so we'll get it done.
Okay,
Thank you.
not a problem. If you need to do the other gentleman first, I can always hop back on.
Yeah, we'll see what happens with them. I'm surprised they're not answering actually. But yeah, we'll see what happens.
Sounds good.
You're Papin, right?
Good morning.
Morning, I have Papin here. Is that good?
Is there any chance that Hotchkiss is there?
Yeah.
Sorry, his attorney's not here yet. Sorry, Mr. Papin.
All right.
She was here, but I sent her away. All right. Good morning, Mr. Hotchkiss. We just have to wait 1 minute and then we can get started, okay?
Okay, all right. How you doing, Ms. Goodman?
Hi, Jay. How are you?
I'm doing all right. How you doing?
I'm good.
I hope you recommend me getting out immediately. No. Good. I already opened my eyes, miss. Ready
That's
open.
good, Jay. Good for you.
Yes, yes, yep,
All right. We're going to get started, okay?
okay.
All right. So good morning. I'm Parole Officer Trisella, and I'm a hearing examiner at the Board of Pardons and Paroles. And this is a preliminary hearing concerning J. Hotchkiss, inmate number 283733. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Yes, Jason J. Hotchkiss, 283733.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Officer Goodman. Officer Goodman, can you please identify yourself for the record?
Sure. Parole Officer Kimberly Goodman from the Mental Health Unit.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's a probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you see at this hearing can be used against you. The hearing is also being recorded, and the testimony at today's hearing will be taken under oath. So, Mr. Hotchkiss and Officer Goodman, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. So we're going to go over the procedure for today's hearing, Mr. Hotchkiss. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state or parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. And that's the procedure. So do you have any questions about that or the purpose before we begin?
No, I have no questions.
Okay, so we're going to go over your rights that you have for today's hearing. So the first right is you have the right to be represented by an attorney at today's hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could represent you at today's hearing?
Yes, yes, I was already informed that.
Okay, do you intend to seek counsel for today's hearing?
No.
No, so just to confirm, Mr. Hotchkiss, you are willing to move forward today without legal representation?
Yes.
Okay, perfect. So then we also, you also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes. Yes.
So now we're going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Goodman, can you please review the charges that you have brought against Mr. Hotchkiss?
Yes, ma'am. Charge number 1 under release direction, program participation. On 1/28/25, you were placed at the App Foundation for inpatient substance abuse treatment due to ongoing use of illicit substances. You were instructed to participate in and complete the program. You left the program on 2 occasions, 2/8/25 and 2/15/25, and used drugs again. Apt requested your removal from the program and you were unsuccessfully discharged from the program for continued use of drugs in a drug treatment program and leaving the premises without authorization of staff or parole. You failed to participate in the program as instructed. Because of your behavior, you were in violation of parole condition number 1, release direction programming. Charge 2, obey all laws. Under drugs, on or about 12/30/24, you used cocaine and marijuana. On or about 1/9/25, you used methadone. On or about 1/16/25, you used cocaine and fentanyl. On or about 1/20/25, you used cocaine and fentanyl. On or about 2/8/25, you used crack. On or about 2/15/25, you used cocaine. As a result of your use/behavior, you are in violation of parole condition number 2, obey all law drugs. Under additional conditions, halfway house placement on 12/31/24, 1/9/25, 1/16/25, 1/20/25. You left Renaissance East, your only approved residence. Your whereabouts were unknown. You did not have authorization from the halfway house or facility or your parole and community service or your parole and community services /PO to leave the property. You failed to abide by the written rules of the facility and your parole conditions. You're in violation of condition number 7, halfway house placement.
Thank you. I'm going to read the evidence that has been submitted because I did re-identify some of them. I separated some of your evidence just to make it easier on my brain. So,
Sure.
For Exhibit A, I have assigned parole conditions. Exhibit B, the remand's actual custody order. Exhibit C, the notice of parole violation /parolee rights. Exhibit D, the parole violation report. Exhibit E, the halfway house agreement. Exhibit F, the BOPP revocation summary. Exhibit G, the Quest toxicology reports dated 12/30/2024. Sorry, just report dated 12/30/2024, and the misconduct dated 1/3/2025. Exhibit H, the residential discipline report. Exhibit I, the incident report CT DOC PCS. Exhibit J, the incident report CT DOC PCS and misconduct dated 1/16/2025. Exhibit K, the voluntary admission /Quest lab results /misconduct dated 1/17/2025. Exhibit L, the incident report CT DOC PCS. Exhibit M, the St. Mary's toxicology results. Exhibit N, the apt incident report. Exhibit O, the apt incident report. Exhibit P, the Renaissance East discharge report. Exhibit Q, the Quest toxicology result dated 1/10/2025. Exhibit R, the misconduct dated 1/9/25. Exhibit S, the misconduct dated 2/8/25, leaving apt. Exhibit T, the misconduct dated 2/8/25, illegal drug use. So, Mr. Hotchkiss, did you receive the notice of parole violation, the parole violation reports, and all the other documents that have been identified for today's purposes?
Yes. Yes, ma'am.
And you were able to review this information as well?
Yes. Yes, ma'am.
Okay. And I did not receive any exhibits from you. Is that accurate?
Yes.
Okay. Do you need any time to submit any evidence for your behalf?
No.
No? Okay. So then at this time, it is the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause towards the charges that have been brought against you. So Officer Goodman, would you like to make any statements towards the charges?
No, I think the charges speak for themselves.
Thank you. And Mr. Hotchkiss, it is now your opportunity to respond to the parole violation charges against you. However,
Yes.
remember that you do have the right to remain silent if you choose to do so. So at this time, would you like to testify regarding your case?
Yes. I know I was in the wrong, and there's a lot of things that I was going through mentally that I was all stressed out and stuff, and going through a lot. And over the repercussion, what I get, I just want to say, I wish I can, I can't wait till I can do things over. And it's been a couple weeks of like, I needed this little eye opener, and I picked up, already like I already wish I didn't commit the mistakes that I made, and I'm ready, and I want to take other steps out there in society to keep on moving forward and do what I have to do to stay positive.
Yeah. So I'm just going to take a moment, and then I'm going to let you know my findings. Okay. So for charge number 1, condition of program participation, I am making a finding of probable cause based on state's exhibits A, D, N, and O. For charge number 2, condition of drugs, I'm also making a finding of probable cause based on state's exhibits A, D, G, K, M, N, O, and Q. And the last one on charge number 3, condition of halfway house, I'm also making a finding of probable cause based on state's exhibits A, D, E, H, I, J, L, P, and R. In addition to my findings, I am also finding that the acts are serious enough to warrant a revocation, and I've determined that you should be detained while you wait your revocation hearing. So the records facility at the records office at the facility will be notified of this, and Officer Goodman is now aware of it. So we will schedule your revocation hearing within 60 business days of your remand, okay?
Yes.
Do you have any questions right now, Mr. Hotchkiss?
Yes. Mrs. Officer Goodman, is there, when I get out, because I want to go back to water, would I be able to have you as my parole officer, even though a violation? I want to show you that I'm going to do positive, and I'm going to fix this mistake, and I'm going to overcome it. And I did overcome. I'm going to overcome.
Okay, that's great. I think that's fabulous, Jay. I don't know. I can't guarantee where you're going to go or who your parole officer is, but if you do come back to Waterbury, there's a high likelihood that it would be me.
Okay, all right.
And
I apologize.
Mr. Hotchkiss.
Yes.
Mr. Hotchkiss, it sounds like Miss Officer Goodwin actually likes to really work with you guys. So work with her, not against her. We'll schedule that revocation hearing. If you want to have representation for that hearing, make sure you send an application to the public defender's office. Just before within the next few days, if you do want legal representation for it, okay?
Okay.
All right, so this does conclude the preliminary hearing for Jay Hotchkiss, inmate number 283733, and you'll be notified of today's hearing, what took place. And like I said, we'll schedule that revocation hearing within 60 business days of your remand, okay? Officer Goodman, would you like to be present for the revocation?
Yes, please.
Okay. All right, so we are all set. You're all set, Mr. Hotchkiss. Good luck, okay?
Okay, thank you. I appreciate it. Bye.
Hi, Jay. Thank you. Thank you, ma'am.
Yes.
Thank you. Have
God
a good
bless
day,
you.
everyone. Bye, thank you.
Yes, ma'am. God bless you. Thank you.
Bye.
Have a good day, hon.
You too.
Talk to you soon. Bye.
Yeah, bye.
Hello, you ready for me?
Hi. Yeah, you can have a seat. I'm just gonna go find your attorney, okay?
All right, thank you.
Okay, so good morning, I'm Parole Officer Trussello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning John Papin, inmate number 282789. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn. You're at New Haven, correct? New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
John Papin, 282789.
This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Papin. Good morning, sir.
Good morning.
So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole. I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose this beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And this hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Papin, can you please raise your right hand? You solemnly swear and solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
I do. Yes.
So we're going to go, perfect. So we're going to go over the procedure for your hearing today. So first I'm going to read you your rights. Then we're going to review the parole violation charges of the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's hearing. Whatever am I? So you will have an opportunity to present any relevant testimony and any relevant documents for the case. After considering all the evidence presented, I'll announce my findings. And if I find that you violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at today's hearing, and we're going to review them now. Your first right is that you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive a written notice of the charges of violation. Did you receive that written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number 1, condition of absconder, the charging officer reported that on 8/19/24, you left the Sierra Center halfway house without authorization. You had no further contact with Sierra Center staff or this officer. You left your only parole-approved address without program completion or permission and became unaccountable in the community. Subsequently, your whereabouts in the community are unknown. On charge number 2, condition of halfway house placement. On 8/19/24, you left your only special parole-approved residence, the Sierra Center halfway house, without authorization and didn't return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. Your whereabouts are unknown at this time. Also, your actions violate your signed halfway house agreement, specifically the clause which reads, "I will not leave the physical confinements of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff." The state has filed the following exhibits that have been pre-marked for identification purposes, and those are Exhibit A, a remand to actual custody order; Exhibit B, the parole violation report; Exhibit C, the notice of parole violation; Exhibit D, the notice of parolee rights; Exhibit E, the signed PCS conditions; Exhibit F, the signed halfway house agreement; and Exhibit G, the Sierra Center halfway house incident report. In addition, the state filed an addendum to the parole violation report on 1/15/2025, and that's also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Elder regarding John Papin, number 282789, the following applies. On 9/17/2024, the Board of Parole issued a warrant based on that report declaring the offender an absconder from special parole supervision. On 9/19/2024, the case was transferred to FIU for investigation. On 1/15/2025, Papin was located by FIU and taken into custody. He was transported to New Haven Correctional Center, and at the AP room, a remand to actual custody order lodged. Papin was served his notice of parole violation and signed his notice of parole rights. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified?
Yes, we have.
I also received an exhibit from the defense. That's Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes,
Great. Do you need any more time for any additional evidence?
we do not.
So we do not have any witnesses today. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges and any of the evidence submitted.
Yes, thank you. As to charge 2, I just wanted to note that the Exhibit G incident report that was submitted was not signed, and it references a video that's not in evidence. I did just want to note that for that charge. I also just had some global comments for both of the charges. I spoke with my client. It is an unfortunate situation. Having done the APT Foundation program, coming out, being sober, he wanted to continue his sobriety while at the halfway house. And unfortunately, he was encountering drugs multiple times a day there. There were people who were using at the halfway house. He also unfortunately experienced people who were using at IOP. He felt like everywhere he looked, he was being surrounded by drugs in a time when he really was trying to avoid those sort of situations and that sort of environment. So I do just want to note that he felt that this was not as important, not a supportive environment to his continued sobriety. And then at the appropriate time, we would like to remark on his background and future plans.
So I have listened to the testimony today. I've also reviewed all the evidence submitted. And with that, Ms. Papin, I am finding that you violated the condition of absconder based on the evidence provided in support of the charge, which is State's Exhibits B and E. On charge number 2, I'm also finding that you violated the condition of halfway house placement based on the State's Exhibits B, E, F, and G. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have the opportunity to speak to your background and history. The purpose of this part of the revocation is to help determine what outcome I will recommend. Cool.
Yes, thank you. My client, Mr. Papin, is 42 years old, born in Bridgeport, raised in Stratford, Connecticut. His primary his primary source of support is from his mother, who resides in Stratford, his father, who resides in Hamden. He has 2 aunts who are very supportive of him as well. One is in West Haven, one is in North Carolina. And then he also is close with his sister who lives in Florida. His primary support right now is his partner, Jacqueline, who resides in Hamden. The 2 are actually expecting their first child together. She is about 3 months pregnant. My client already has 2 children, ages 15 and 9. Most recently, while released to special parole in March of 2024, my client was first sponsored by his father at an address in Hamden from March 7th until May. Then May to August, he successfully completed the Time Out program. After that, from August 5th to August 19th, he was at Sierra Center in New Haven. In 2019, my client began studying human services at Ashland Community College. Between the general studies classes and the human services classes, he had done about 27 credits and was reportedly on the dean's list. He is hoping to continue that. He has a history of working in construction. Most recently, he was doing handyman jobs and was offered a position at Whole Foods Distribution Center in Cheshire, but he was unable to begin that before remand. He previously was employed full-time at Bell Nursery in North Haven. That was a seasonal position. Most recently, while on supervision, he successfully completed the Time Out program. He was doing medication-assisted treatment, methadone, at CASA, Multicultural Addiction Services in New Haven. He was participating in individual therapy out of New London with a private therapist named Jasmine. He also was doing 12-step meetings about twice a week. Since this remand, he's been on the wait list for a job as a tierman in the facility. On the reinstatement of a special parole, he would like to be sponsored by his significant other, Jacqueline. We provided that address on the paperwork along with her information. So you could check out the so that the PO can check out the residence prior to, but he is hoping to be sponsored by her. She is a great sober support for him, and he feels very strongly that he can succeed if given the opportunity to stay with her. He also is wanting to return to Ashantuck Community College to finish human services programming and enroll at the NETS program for tractor trailer training school to try and get his CDLB. He wants to go back to full-time construction. That will be with one of his friends' companies, Maddox Roofing, out of New Haven. He's open to any sort of treatment recommended, medication management, 12-step programming, and is looking forward to also establishing a doctor in the community. As an alternative to the sponsor, he is open to a halfway house in the New Haven area if needed, but he is in preference of having his sponsor be his partner. I will also note my client wants me to note for the record, he is amenable to any sort of additional monitoring that Parole may want to impose, if they want to do like a GPS or something. He's open to any sort of additional monitoring like that. I will note that even though my client was in absconder status for some period of time, he reports maintaining sobriety that full duration. Again, as I stated before, his partner has been a huge sober support for him, and she has been just such a good change in his life. He also notes that during that time he was working with a therapist. This isn't a situation where he returned with new charges. I would ask that his sanction not exceed 4 months. He's lost, he has a lot of support in the community. He would like to get home to help his partner. They are expecting their child. And I believe at this time my client may have a letter that he wants to read.
Yeah, I'm sorry completely. I've been up for 2 days. I got an infection in my mouth, my tooth, and my whole face is throbbing. I haven't eaten and I completely forgot it.
That's okay. Did I cover most of it?
You covered the most of it. I'm no longer on methadone treatment. I got off of that due to, as she said, the negative going to IOP and going there every day. I needed to get away from that. I would like to get back on my mental health medication because I got anxiety and depression, and that's part of the factors that factors into it. Parole stipulated that I stay on them. I'm having problems getting on them here in DOC. So as soon as I do get out, I plan on going back on them. And it's just, I made a bad choice. And I'm just trying to move on from it and be there for my child and help financially. I can't do that from in here. And so I'm just asking for your mercy and see what happens. Thank you.
Thank you.
Thank you.
I had a really good letter though. The letter was good.
Oh no. I was gonna say next time, but hopefully there's not a next time.
No, there isn't a next time. I don't want to, no next time.
No next time. So we'll let you know my recommendation in a moment. So I have listened to today's testimony and I reviewed all the evidence submitted. With that, I am recommending that your parole be revoked, Mr. Papin, and that you serve an approximate 5-month period of confinement. That's a reparole date of June 15, 2025. And with that, I recommend the following condition: no contact with co-defendant Joseph Dennis, and PCS has requested that you do a halfway house stipulation. So I'm going to do that, but I will put the information in for your sponsor. It's ultimately their decision. So just so you know where my recommendation is coming from, you were only in the community for about 1 month in between your reparole and remand. So that was taken into consideration. Your history, you've also absconded from discretionary parole. So I just try to make better decisions. I know it seemed like the right decision at the time, but gotta weigh.
And I definitely wasn't.
Yeah, so my recommendation is going to go to the board on March 13th, 2025. On that date, the board can do a few things. They can adopt my recommended sanction. They can actually reduce it if they choose to do so, or they can ask for a supplemental hearing if they want to talk to you to maybe impose a sanction longer than what I recommended, okay?
Yeah.
If that does happen, you'll be notified, Attorney Dean will be notified. There will be a full other hearing for you to address their concerns. So do you have any questions at this moment?
No, that's pretty good.
If you call my office next Thursday afternoon or the following Friday, we can let you know what the board decides, okay?
Yeah, can I get your number so I can call it from the blue phone instead of going through the counselor? Because I can just call you from that. It's a private, it's the lawyers. If I press 0, it's a non-recorded.
So I believe they are still recorded, but I can just give you, I don't know if you have a pen and paper. I could email your
I have it.
counselor
Yeah.
to go ahead
I'm gonna
and
grab
set
a pen
something
real
up.
quick. Yeah, I'm gonna
Okay.
grab a pen real quick. Thank you.
Okay. Yeah, I can give them the office number.
All right, what it is?
It's 203-596-4370.
Yep.
Yo, I was trying, I said maybe you facing like a way.
4370.
Yeah.
All right, thank you.
All right. Thank you very much.
Okay, this concludes the revocation hearing for John Papin and number 282789. All right, you're all set. Good luck, Mr. Papin.
Thank you. Have a good day. I'll talk to you
Take
next
care.
week.
Talk to you soon.
So I'm not sure why you're not able to connect with one another.
Sorry, Kristen, are we trying to connect with Bridgeport Video 1?
Yes, we use Video One at every facility.
Yeah, so I'm sending a call. They're not accepting the call. I have a lieutenant on the phone. He's saying that they're in the Video One room in Bridgeport, but they're not connecting. Is there any advice?
He's there in the room right now?
That's what you said, right, Lieutenant?
Yeah, he's in there right now.
Yeah, he's in there right now. So just try to keep calling.
I'm dialing them myself right now. What he should see is on the tablet, there'll be a pop-up that says BOPP is trying to connect. Do you want to accept this call? And then there's an accept button. So they just need to press the accept button on the tablet.
Do you hear that by any chance?
No, I didn't.
No, if you can ask the officer to just hit the accept button on the tablet.
All right, let me tell you.
Okay, thanks. Did your prosecutor get it too?
Yeah, yeah, he did from today. I watched it to see how he did. But
All right, I relayed the message. Please call me back if you run into any issues.
Okay, great. Thank you.
All right.
Just an FYI, Kristen, he said he relayed the messages the message and just to call back if we have any issues, but it looks like they're still not connected, correct?
They haven't yet, but the call takes about a minute to time out before I can dial again.
Awesome. I see you. Can you hear us?
We can hear you. We can't see you. Now we can. Call for Mr. Tallman, correct?
Yes, thank you. Hi, Mr. Tallman.
Hey.
Okay, so we can just get started in a moment. So good morning, I'm Parole Officer Tricello. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Dasan Tomman, inmate number 369506. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Bridgeport Correctional Center. Can you please state your full name and DOC inmate number for the record?
Dashawn Tomman, 369506.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
yes, Hannah Dean on behalf of Mr. Tallman. Good morning, sir.
Good morning.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Tallman, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
Yes, I do.
Thank you. So we're going to go over the procedure for your hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
So you do have important rights at today's hearing, and we're going to review them now. Your first right is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of the charges of violation. Did you receive that written notice?
Yes, I did.
Good. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine any adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I am.
Okay, so we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So on charge number 1, condition of absconder, the charging officer reported that on 10/5/2023, you signed out of your approved residence, Isaiah Halfway House, on an approved work pass at 6:30 a.m. with a return time of 5:30 p.m. You failed to contact your parole officer or Halfway House staff and failed to return to the program by the return time. Your whereabouts are unknown at this time. On charge number 2, condition of travel, the charging officer reported that on 1/6/2025, you were apprehended by the state of New York and signed a waiver of extradition in court in New York on 1/6/2025. You did not have permission to leave the state of Connecticut. Based on your actions, you were in violation of your release condition travel. On charge number 3, condition of halfway house placement, the charging officer reported that on 10/5/2023, you signed out from your approved residence at Isaiah Halfway House on an approved community pass for work at 6:30 a.m. with a 5:30 p.m. return time. You failed to contact your parole officer or halfway house staff, and you failed to return to the program by the return time. Your whereabouts are unknown. Your actions violated your assigned halfway house agreement, specifically the clause which reads, I will return to the halfway house, my only approved residence, at my scheduled return time. If I am unable to do so, I will call the halfway house staff to explain why I am expected to be late and to receive a new return time. I will remain in phone contact with the halfway house staff until I return to the program. The state has also filed the following exhibits that have been pre-marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the signed PCS conditions, Exhibit E, the signed halfway house agreement, Exhibit F, the Isaiah halfway house incident report, and Exhibit G, the signed waiver of extradition. And they have submitted an addendum to the parole violation report on January 13, 2025, and that is also admitted into evidence. And that reads as follows. In reference to the parole violation report submitted by Parole Officer Elder regarding Tallman, Dashawn, number 369506, the following applies. On November 2nd, 2023, the Board of Pardons and Paroles, BOPP, issued a warrant based on that report declaring Tallman an absconder from parole supervision. On November 6, 2023, the case was transferred to POC Parole Fugitive Investigation Unit for investigation and apprehension. On April 24, 2024, a lead packet was sent to New York Police Department, NYPD, Fugitive Enforcement Unit, requesting assistance with apprehending Tallman, who was residing with his wife, Regan, Canada, in Brooklyn, New York, on June 3, 2024. NYPD attempted to serve the warrant but was unsuccessful. However, they agreed to keep the case active to continue the collaboration with ZT Parole Fugitive Unit. On January 6, 2025, Tallman was apprehended by NYPD and is currently being held as a fugitive from justice at the Eric M. Taylor Center, EMTP, awaiting extradition. Yes, to Connecticut. On 1/16/2025, Tallman was extradited back to the state of Connecticut and a remand to custody order was lodged at BCC. Please note this is Tallman's second time absconding from special parole supervision since his discharge of special parole on 11/13/2020. Tallman previously absconded on 8/10/2022 and was returned to custody on 11/7/2022. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified?
Yes, we have.
Great. And then I have received exhibits from the defense. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, a letter of support, Dina Franchi, LCSW. Exhibit 3, a letter of support, Caden Client's son. Exhibit 4, letter of support, Raven Canada Client's partner. Exhibit 5, a letter of support, Margaret Oaks Home Health Aid. Exhibit 6, a letter of support, Ethan Canada Client's son. Exhibit 7, a letter of support, Henry G. employer, and Exhibit 8, a letter of support, April Drew, mother of Raven, Canada. Is that accurate, counsel?
Yes,
Sorry, do you need any time to submit any additional evidence?
we do not.
Okay, so we do not have any witnesses today, so now it is the time for the defense to call any witnesses, present evidence, and speak to the charges and the evidence submitted.
Thank you. As to the charges, I just have some global comments. I want to start by noting that my client had been struggling while on parole supervision with support in the Connecticut community. He very unfortunately lost his mother in December of 2022, who was his primary support. And thereafter, his father, who was his sponsor for a time, but his other means of support in the state, unfortunately has been struggling with severe dementia. So unfortunately, it was a situation where he was unable to house my client. My client's support system kind of vanished here to no fault of his own, but to, the unfortunate loss of his mother and the medical issues his father was enduring. And his entire support system at this point is in New York City, where his partner and all of his children reside. So I will just note that. Additionally, my client did explain to me sort of what was going on at the halfway house prior to all of this. He indicates that when he went to the halfway house, he's used to the process. He was expecting to go through all of the intake paperwork, have someone go through with him, sign everything, not have sort of anything left to the imagination. He did immediately start working, but unfortunately the intake paperwork wasn't done with him for a number of days. When they did do the intake paperwork, he indicates that the PO was kind of rushing through it. And at the time, they didn't say anything about charging rent. He was just told to start his own bank account, which he did. So several weeks went by. He was sending money home to care for his family. He was doing what he was supposed to be doing, buying, work supplies. The PO even went with him on one occasion to buy work boots. So he knew that he was making money, saving it, doing what he needed to do. And it wasn't until he was there for about, I believe, a month or so that he was told, okay, now you owe rent. At that point, my client, since he was somewhat blindsided by the request, told the PO that he wanted to work with them. He was happy to make additional payments to get back up to good standing with the rent, but was met with resistance. He also indicates from the jump asking to be referred to the interstate compact personnel to start the process so that he could try and go home to reside with his family and be on parole supervision in New York. But he unfortunately reports some resistance by the PO and staff with helping him in that process. So it was an unfortunate situation, but this isn't a scenario where there's charges he's returning with. He did voluntarily waive extradition from New York. So I do just want to note all of that. And at the appropriate time, I would like to remark on his background and future plans.
So I did listen to the testimony. I've also reviewed all the evidence submitted. With that, I'm going to make a finding for charge number 1, absconder, based on the state's exhibits B, D, and F. I'm also making a finding on charge number 2, condition of travel, based on state's exhibits B, D, and G. And I'm making a finding for charge number 3, condition of halfway house placement, based on state's exhibits B, D, E, and F. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have the opportunity to speak to Mr. Tallman's background and history. And the purpose of this part of the revocation is to help determine what outcome I will recommend. Counsel?
Yes, thank you very much. My client, Mr. Tallman, is 32 years old, born and raised in Danbury, Connecticut. His primary support system is his partner, Raven, Canada, and her family, who reside in Brooklyn, New York. They've known each other for about 22 years. Mr. Tallman's mother, as I stated previously, unfortunately passed away in December of 2022, and his father has been suffering with severe dementia. My client has 5 children and another on the way. They're expecting their 6th child to be born in May of 2025. Most recently, while he was on special parole in August of 2023, my client was at Isaiah Halfway House in Bridgeport. His father previously sponsored him from 2020 to 2021, and he previously utilized the Sierra Center in 2021. He reports that he started the music production program at Full Sail University in 2013-2014. Most recently, while on supervision at the Isaiah Halfway House, my client was working full-time for a waste management company in Bridgeport, Connecticut for approximately 2 months. After that, he reportedly worked for a moving and cleaning company out of New York City. My client does have a medical history. This includes diabetes, asthma, high blood pressure, high cholesterol, and neuropathy. He may have also a cardiovascular issue. He's experiencing fast pulse lately. He does have primary care services established in Brooklyn, New York. In the past, beginning in 2021, he completed about 25 to 30 hours of community service as well at Terrell Park and Mansion in Danbury. Since he's been remanded, my client has been medication compliant, taking meds, I believe, for anxiety and depression. He meets with a social worker once weekly, finds this to be helpful, and he's also on the wait list for employment. Upon being reinstated to special parole, my client would like to go through the interstate compact procedure in order to transfer his parole over to New York so that he could be sponsored by his partner at an address provided to the board for Brooklyn, New York. He's eager to be back with his partner and help with the birth of their child and just be present in his children's lives. All of his support system is now in New York. In the meantime, he's amenable to being placed in a halfway house in Bridgeport until he's able to get the interstate compact stuff underway. He's wanting to re-enroll back at the Full Sail University to do that music production program. Should he be placed in Bridgeport, my client can return to his position that he held previously with the waste management company. In New York, he also has an open availability to return to the moving and cleaning company. We did submit a letter, that's Exhibit 7. He's also open to treatment recommendations, including individual therapy and medication management in the community. I understand this is a situation where he's charged with absconding, but I am requesting the soonest possible release date for my client. This isn't a situation where he returned with new charges. It appears from everything that has been presented that my client was keeping his head down, working hard while he was even in absconder status. I believe he was just working to provide for his family. His partner truly does rely on him. She has a number of different health issues that limit her availability to bring her children to school and do a number of different things for them. And my client was, I think, an enormous help to both her and her family. And also he was just, you know, a huge support for his children being in their lives. He, again, didn't pick up new charges. His family desperately wants him home, as you can see from all of the support letters that were submitted. I will also just note my client was remanded on 1/16/25, but he was incarcerated 10 days prior to that at Rikers in New York City on the extradition. So he has been in incarceration since January the 6th. I would just ask that you take that into account in crafting your recommendation. So I would just ask for the soonest possible release date for my client. He is not somebody who is going out and picking up new cases. I think that if he's given this opportunity, he will do the right thing. He will support his family. And most of all, he just wants to be there for his partner, especially during the birth of their new child. Thank you very much.
Thank you. Take a moment, I'll let you know my recommendation. Okay, so I have listened to today's testimony and I did review all the evidence submitted. And I just want to make some notes for the record. So this is Mr. Tallman's third violation of this term of special parole. He was only supervised in the community for 2 months prior to absconding this time. And he was on absconder status for approximately 15 months. This is his second time absconding as stated by the evidence presented by Parole and Community Services. So with that, I am recommending that your parole be revoked, Mr. Tallman, and that you serve an approximate 1 year period of confinement. I will take the consideration of your 10 days at Rikers, and so that's with the re-parole date of January 6th, 2026. So it's a 10-day less of a year. With that, I'm going to recommend the following conditions: no alcohol consumption, behavioral management for domestic violence, no contact with the co-defendant Michael Brown and Rebecca Vaughn, no contact with victims VL, RP, and RL, mental health treatment. And I am going to do a halfway house placement because the interstate compact takes 3 months of compliance in the community for you to request to go interstate. And that takes an additional time period for New York to accept your request and for us to accept your request to move forward with it. So it is a lengthy time that you do have to put in the work here in Connecticut, unfortunately, to get back to New York. So after 3 months of compliance in the community in Connecticut, you can ask your officer to submit the paperwork for you, and then you have to wait for a decision from New York to then move forward with that interstate compact. So those are my findings and then my recommendations. I'm going to forward them to the board on March 13th, 2025, and you'll receive a written notice from the board shortly after that. Note at that hearing with the board, they can do a few things. They can lessen my recommended sanctions. They can impose it, or they can recommend a sanction longer than what I've given you because your special parole, do I have an end date?
It's 2027.
It's 2027. So if they want to, yes, I have April 26, 2027. So if the board wants to do a sanction longer than what I've recommended, there will be a supplemental hearing that you'll be present for to address their concerns, okay?
So Mr. Tallman, if you would like to call my office after the 13th, either that afternoon or the following business day, we can let you know what the board decides, okay? And if they do decide a greater sanction, we would get another hearing that we could work together for, okay?
Yeah. Okay.
This concludes the final revocation review for Dasan Tomman, inmate number 369506. Are you all set, Mr. Tallman?
Great. Thank you very much, sir.
Take care. Shoot. Hi, you're here. I thought you could log in. Hi.
I'm sorry, how are you? You want us to be live?
I haven't seen you.
I know, and I just.
Mr. Moore, it is 11:27 and we cannot start until exactly 11:30. Okay, so we'll be with you in about 3 minutes.
Yes, ma'am, I understand.
Okay, sounds good. Do this. Okay, good morning. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Clayton Moore, inmate number 387396. Today is Monday, March 3rd, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Clay Moore, inmate number 387396.
Thank you. This is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Jones. Attorney Jones, can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there's a preponderance of evidence, to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I found that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. Attorney Jones, can I swear your client in?
Yes.
Okay. So you should know that the revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Moore, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're going to go over the procedure for your hearing now. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't have any questions. I just want to ask you, can you please tell me when I can speak before you give your decision, please?
Sure. Yes. Yeah. Yeah, we'll go
Thank
through
you.
all of those motions, okay? So we're gonna go over the rights that you have right now, for this hearing. So the first is you have the right to be represented by an attorney, and counsel is here present for you. You have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes, ma'am.
Good. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights and are you ready to go forward?
Yes, ma'am.
So we're going to review the charges that the state, your parole officer, is bringing against you and the underlying information for each charge. So in charge number 1, condition of absconder, the charging officer reported that on October 19th, 2022, you left the Walter Brooks halfway house without authorization and failed to return to your own parole and community services residence, the Walter Brooks halfway house located at 680 Howard Avenue, Haven, Connecticut. Your whereabouts in the community are unknown. Charge number 2, condition of obedience to the law. On 12/19/2023, you engaged in reckless endangerment, first, assault of a disabled person, third, threatening, second, and conspiracy to commit assault of a disabled person. Subsequently, a warrant was issued for your arrest from New Haven Police. On charge number 3, condition of halfway house placement, on October 19, 2022, you left the Walter Brooks halfway house without authorization and failed to return to your only parole and community service residence, the Walter Brook halfway house located at 680 Howard Avenue, New Haven, Connecticut. Your whereabouts in the community are unknown. The state has filed exhibits, and I have remarked them. Oh, I added an exhibit I, which is the parole violation report. So I'm going to identify them as follows. Exhibit A, conditions of parole. Exhibit B, parole violation notice. Exhibit C, the halfway house agreement. Exhibit D, the halfway house discharge plan. Exhibit E, the remand into custody. Exhibit F, the parolee rights. Exhibit G, the halfway house incident report. Exhibit H, the New Haven Police Report 23-050536. And Exhibit I, the parole violation report. In addition, the state has filed 2 addendums to the parole violation report, and they are both also admitted into evidence. The first one was submitted on 12/18/2024 and reads as follows. In reference to the parole violation report submitted by P.O. Barnes regarding Clayton Moore, the following applies. On 12/20/2022, the Board of Parole issued a warrant based on the report declaring the offender an absconder from parole supervision. On 12/21/2022, the case was transferred to FIU for investigation. On or about 12/19/2023, Moore committed 53A-61A, assault of a disabled person, third, 53A-63, reckless endangerment, first, 53A-62, threatening, second, and conspiracy to commit assault of a disabled person in New Haven under case number 23-050536. On 12/13/2024, New Haven PD took Mr. Moore into custody and a remand to custody order was lodged with New Haven PD records. On 12/17/2024, at New Haven Correctional Center, Moore was served his parole violation, was provided with his parolee rights. The signed notice of parole violation, parolee rights, and remand were scanned into case notes on 12/18/2024. Mr. Moore has a court date of 1/7/2025 under docket numbers N23N-CR24-025750-3-S, N23N-CR24-025750-5S, N23N-CR24-025750-8S, and N23N-CR24-025750-10S. The second addendum was submitted on January 28th, 2025, and that one states that on January 28th, 2025, Mr. Clayton appeared before GA 23 New Haven for several charges. For the charge of breach of peace second under docket number N23N-CR24-02575010, Mr. Moore received a nollie. For charges of threatening to 53A-62, reckless endangerment first, 53A-63, and breach of peace second, 53A-181. Mr. Moore received a nollie under docket number N23N-CR24-025750-8S. The charge of 53A-61A, assault of a disabled person, third, was not pursued under the same docket number. For the charge of breach of peace second, 53A-181, he received a nollie in the charge of criminal trespass first, 53A-107. He pled guilty and received 11 months jail, execution suspended, and 2 years probation under docket number N23N-CR24-0257503S. For the charge of assault third degree, 53A-61, Mr. Moore received 11 months jail, execution suspended, and 2 years probation under docket number N23N-CR-24-0257505S. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified for today's hearing?
Yes.
Okay, so I am somewhat confused by the addendum submitted, counsel. Do you know the result of the conspiracy to commit assault second of a disabled person?
So, there was a substituted information that was filed. So what that did was the substituted information removed the charge of assault on a disabled person, a conspiracy to assault on a disabled person, and replaced that charge with an assault on the third degree. So when there's substituted information that is filed, it in effect is replacing the existing charges with new charges, different charges, as if the original charges never existed.
So the assault third that PCS put in the addendum was subbed down from the conspiracy?
Yes.
Okay. So to assault.
So it's not simply that those charges were not pursued, because when a charge isn't pursued, it's typically nollied. Okay. It's that those charges were removed.
Okay.
So it's as if they never existed.
So the criminal trespass one also was a sub down, do you believe?
No, I that must have been an added charge, because that does not appear to have been an original charge.
Okay.
And it's a different docket number.
It is not an original charge.
So
Okay,
if you see that was a different docket number.
Yeah.
So perhaps it was not even what they're speaking of here.
So not part of the
because it was a completely different docket number.
However, just to confirm, the assault 3 is a sub down from the conspiracy.
Yes.
Okay. Which is what the charge.
Yes.
He was charged for.
Exactly.
Assault third, and that sentence is correct. I don't know if this is the right point to say that, but that sentence, well, we can get to that, right?
I mean, if you want to actually see the.
It was just the 11 months.
Yeah, so here's the assault third disposition. Right, and then see all of those charges that were nollied.
Everything that's nollied.
Yeah, and so because these charges still part of the same exact docket number, it was only a substituted information on those assault charges.
Okay.
The substituted information did not replace these. These were just nollied.
Just nollied.
Yes.
Okay.
All right. There's an additional docket number, but this again, I don't believe this was part of the violation. And then this one again, which I don't believe appears to be
wasn't even part of it.
Yes.
Okay. All right. Sounds good. Thank you. I do appreciate it.
And so so they did include that as a part of the addendum. So I don't know that it was. Yeah.
Okay. Thank you.
You're welcome.
So again, you did receive everything as well, correct?
Yes.
Okay, great. So I also did receive exhibits from the defense. So I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, the letter of support from Amica Moore, client's mother. Exhibit 3, I'm changing this. I'm assuming it says it's 2022. Actually, I'm not. I read it.
Yes.
I read it. So no, that's fine. 2022 W-2 wage and tax statement for Clayton Moore. Exhibit 4. Lockworks Hospitality Group LLC pay stubs. Exhibit 5, the 7-Star Hospitality W-2 wage and tax statements, and Exhibit 6, a letter of employment from Mara Woodhouse, the hire manager at Kentucky Fried Chicken. Counsel, do you and your client need any additional time to submit other evidence?
No.
So we do not have witnesses today, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to the charges.
Thank you. In regards to charge 1 absconder under release direction, just by way of mitigation, my client was living at the halfway house. He was employed, gainfully employed, paying rent. And he does tell me that a fight occurred and that he panicked and didn't want to be there. He tried to sponsor to his mother's house, but was unable to at the time because she was Section 8, and he was unable to. So then he made a bad decision. I think he understands that that was not, the appropriate thing to do. But during that time period that he was in absconder status, which is, I believe, approximately 2 years, he was staying with his mother. He was her caregiver. He does have 2 younger siblings who he was also taking care of. He was, in fact, working 2 different jobs at one point, 3 different jobs, in fact, at one point: Boston Market, Chili's, Horns Tavern in North Branford. And he was claiming his mother and his younger siblings as dependents on his tax returns. So he was a productive member. And unfortunately, it wasn't the right way to do it, but just by way of mitigation, would think it was important to know. In regards to charge 2, under obedience to the law, I think we just kind of clarified the addendum and exactly what transpired there. I would point out that domestic violence case ultimately did involve his mother, but as you see, there is Exhibit 2 was an email that his mother submitted in support of him, just indicating, that he was taking care of her, he was working, and just kind of a character reference. It's unfortunate that he went to court and he obviously attempted to resolve that case as quickly as possible so that he could have his revocation hearing. So just point that out as well. No comments as to charge 3.
Mr. Moore, is now the opportunity? Do you have?
I would suggest at the end when we're talking about his background history. I believe you have a prepared statement. Is that?
I do, but I'll probably just will fold it up and just speak briefly on the things that you have said. That's all. Yes, at the end, whenever it's okay with y'all. Yes.
Yes. Okay.
So no comments. Yes. Charges. Okay.
Yeah.
All right. No problem. All right. So I'm just going to take a moment. So for charge number 1, Ms. Moore, I am finding that you violated the condition of absconder based on states exhibits A, D, G, and I. On charge number 2, I'm finding that you violated the condition of obedience to the law based on your conviction of assault third, wherein you were sentenced to 11 years, execution suspended after 2 years of probation.
11 months.
Sorry. Definitely 11 months. Thank you. Sorry, 11 months, execution suspended, followed by 2 years of probation for the assault third. In addition, I am following evidence supports the charge, which is exhibits A, H, and I. On charge number 3, condition of halfway house, I'm also finding that you violated that condition based on states exhibits A, C, G, and I. So that does conclude the fact-finding portion of today's hearing. At this point, you will now be able to take the opportunity to make a statement speaking to your background and history. And the purpose of this part of the hearing is to help determine what outcome I will recommend. So counsel, would you like to start?
Yes, thank you. My client is 20 years of age. He's single. He does have 1 child. He is a high school graduate. And during his time in the Department of Corrections, I think it's important to note that he was accepted into and participated in the TRUE unit for approximately 2 years. And as you know, that's a difficult program to get into within the Department of Corrections. And he was in that program for approximately 2 years. He does live with some mental health issues. He was in the community for approximately 4 months prior to the absconding time. And I will note that he did utilize the assistance of a halfway house. He worked with Project Moore Halfway House program, as well as the Walter Brooks Halfway House, which is part of noted in this violation. He does have a support system in the community. He has his mother, his grandmother, his siblings. And during the time that he was in the community, he held several employment positions, working at Shell and Bones Oyster Bar, Boston Market. We do have a letter from Boston Market, which is Exhibit 3. Chili's, Lockford's Tavern. Not a letter, but pay stub. I'm sorry. And again, he was working, taking care of his mother, taking care of his younger siblings who are 17 and 15. And then just by way of behavioral health treatment, he was receiving medication from Kana Health. When he is re-paroled, he's asking to be placed as a sponsor at Destiny Gibbs, who is a significant other. Her information is provided within Defense Exhibit 1. He's also offered as an alternative to Ms. Gibbs, a halfway house in the New Haven area. He does have plans to return to pursue educational endeavors, as he would like to a culinary arts program, as he does aspire to be a chef, as well as perhaps enrolling in an HVAC program at Porter and Chester as a ways to make a living. He does have employment opportunities though available to him to return to both at the Lockswood Tavern as well as at KFC in New Haven, and that's noted as Defense Exhibit 6. He's amenable to all treatment recommendations, including individual as well as group therapy, and he simply is asking for another opportunity to be released out to the community and have some success. I believe he does not end his sentence until October of 2026, if that's accurate. I have October 19th of 2026.
I have October 10th of 2020.
Okay, some time came off of that. Okay. So he certainly could benefit from being supervised in the community. So we would be asking to take all of these things into consideration. He has been incarcerated now since I believe December 13th. So we would be asking that he be re-paroled at the earliest possible date. And I believe he would like to address you.
Absolutely. Go ahead, Mr. Moore.
Yes, I just want to say thank you for giving me this opportunity. I actually wrote a letter, but I wanted to speak from the heart. Everything that my lawyer has said is actually true. I actually was working while I was absconder. When that situation happened in the halfway house, due to me having an anxiety attack, which I had multiple of them before, it's probably noted in one of the paperworks that I received. It said that I have been to Yale emergency room for having anxiety attacks inside the halfway house. It's something that I can't control. It's something I don't know too much about. You know, they prescribe me marijuana and they want to prescribe me Xanax, but I'm not going to lie. My mom, she has a lot of like issues and she take a lot of pills. So by seeing her take pills, I never really wanted to take pills. So I was just okay with the prescribed marijuana. What I would like to say is I'm very reformed. The TRUE program helped me a lot. As you see, I built a resume. Every time I go to a job, I get hired. I don't think any job I ever been to, I didn't get the job. So I just want to notice that out there. And the fact that I did catch new cases, the new case was due to my mom having a bunch of mental issues. That's why it got so resolved so fast. If I could have waited any longer, I probably could have got every charge not only due to the evidence that I did have, but I wanted to come see the parole board so fast because I also want to be released fast to get back to my family, because me and my younger siblings never had a father and I'm like the only help. So I just don't want them to, you know, not give up either, due to the fact that I'm the only one that can help them and my mom. So I'm just going to just leave that there and hope that you can understand that I do care for my life and I can succeed in the community. Thank you for your time.
And just to add on to his comments, I would note if you took a look at the DIS report, it does indicate in his history that his mother did struggle with substance abuse issues. She is disabled now. I'm not certain if that's as a result of her substance abuse issues or not, but she does have two younger children, and my client, did move into that home in order to assist not only his mother, but with helping with the two younger siblings due to the fact that the mother is disabled. I think it's unfortunate that there was an incident that required police contact. And as he's indicating, it certainly could have been a situation where had he pursued the charges, they all could have been dropped, but obviously he would have spent probably more time incarcerated attempting to do that. And, he wanted to resolve the matters as quickly as possible. So those would be my last comments, but thank you.
Thank you. I'll get my recommendation to you in a moment. I have reviewed all the evidence submitted, and I did listen to today's testimony. However, I do want to note some information that has been submitted and for his record. So this is your second time violating this discretionary parole, and both have been for absconding and new criminal charges. So that is concerning to me. Also that you were only supervised for 4 months before you absconded this time. And I do hear that you were helping your family and working. It's just you also had the opportunity to turn yourself in, I feel like, during those times. And there's just the right way to go about it. Okay, Mr. Moore. So with that, I am going to recommend your parole be revoked and that you serve an approximate 15-month period of confinement with a re-parole date of March 16th, 2025. That will leave you approximately 6 to 7 months for supervision until your end of sentence. Sorry, March 16th, 2026. I am not okay right now. So that's a 15-month period of confinement. One more time, March 16th, 2026. That leaves you about 6 to 7 months until your end of sentence, which is October 10th, 2026. With that, I'm recommending the following conditions: behavioral management program for domestic violence, no contact with the co-defendant Shane Gray or Joel Cruz Barrios, no contact with your victim DV. I do have a general no contact with OM without your parole officer's permission, mental health evaluation, and I am going to put in a halfway house stipulation because it is up to Parole and Community Services about housing, but I will let them know that you have requested to stay with your significant other, correct, Ms. Gibbs?
Yes.
Yes. So that is my recommendation. It's going to be forwarded to the board on March 13th. And on that date, the board can do a few things. They can adopt my recommended sanction, they can lessen it, or if they want to do a sanction longer than what I've imposed, there'll be a supplemental hearing, and you'll be notified of that because they'll want to speak to you about it before they make their they make their sanction. Do you have any questions right now, Mr. Moore?
15 months is a long period of time. That's one thing I can't say, but you gave me a recommendation. I'm just going to say thank you. I was even if you would have said a year, ma'am, you know what I'm saying? I would be like, okay, because it was my second violation. But I guess just thank you and have a blessed day.
Thank you. So this does conclude your revocation hearing. And we're going to go off the record.
Yeah, Clayton, if you have any questions, we want to talk about anything else, just give me a call, okay?
Okay.
Okay. All right, you're welcome.
Final revocation for Clayton Moore, inmate number 387396.
Good luck.